Hello everyone and welcome back to the channel. I'm Brandon Silver, a construction, contentious and transactional lawyer, and today we're covering a very important topic, limitation periods. Knowing the limitation periods that apply to construction claims can be crucial for protecting your rights and managing risk. So today we're going to talk about what limitation periods are, why they matter, and the key time limits to keep in mind. So first of all, what are limitation periods? In legal terms, a limitation period is the maximum time allowed to bring a claim after an event has occurred. If you miss this window, you may lose the right to make that claim regardless of its merits. The defendant will have a full defense to say that the claim is time barred. In construction, limitation periods apply to various types of claims, including breaches of contract, defects, and unpaid work. So being aware of these time limits is very important to protecting your position. So why do limitation periods matter in construction? They matter because many issues, such as by way of example latent defects, may not surface until years after the project is completed. As I've just said, if you miss the window to file a claim, it could mean being left with no legal recourse for those latent defects or any other issues that arise post-completion. On the other hand, for contractors, limitation periods help provide certainty and closure, setting clear limits on liability over time. So let's now get stuck into it, and the first limitation period we're going to talk about is simple contracts. Now, a simple contract is a contract known as a contract executed under hand, and the best way of explaining it is it's a contract which has not been executed as a deed. And I will talk about the limitation periods for deeds and what is a deed in a moment. But if you have a simple contract, the limitation period is 6 years from the date of the breach. So if we take an example where there's a contractor and employer that have entered into a contract, and it's a simple contract which has not been executed as a deed. If a contractor fails to complete work as agreed under a simple contract, the client, the employer, would have 6 years from the date of the breach to bring a claim. We're now going to talk about deeds. With deeds, the limitation period is significantly longer. It is 12 years, not 6 years, so it is double. Now, what is a deed, therefore, you ask? If the contract is a deed, it is a document which has met the following 4 requirements. It must be a contract in writing, it must make it clear on its face, i.e. on the document itself, that it is a deed, it must be executed correctly, and it must be delivered correctly. Because of the ramifications of entering into a deed as opposed to a simple contract, that being that the limitation period is 12 years, not 6 years, I would always advise that you get legal advice from someone like myself to make sure that the contract has been executed correctly if you want to make sure it is a deed. So as I've just said, the limitation period here is 12 years from the date of the breach, not 6 years. And my advice is that if you ever have a high value project and you're employing the contractor on this, it should be executed as a deed because it gives you that significantly more protection of 12 years and not 6 years. We're now going to talk about, and I've already briefly alluded to it, latent defects, because there is a nuanced limitation rule here. As I've just mentioned, one of the biggest concerns is latent defects, because these are defects that are not immediately apparent after completion, but that surface over time, such as by way of example, structural issues. In these cases, the limitation period is still technically 6 or 12 years from the date of the breach, depending on whether the contract was executed as a deed or is in fact a simple contract. However, for some latent defects, there is a concept called the discovery rule, which has been introduced by way of the Latent Damage Act 1986. In short, this rule gives claimants 3 years from the date they discovered or could reasonably have discovered the defect to bring a claim, provided this date doesn't extend beyond the long stop date of 15 years from the date of the original breach. There is that long stop date fixing that. Another common area in construction is professional negligence claims, such as those against architects or engineers. These claims have a 6-year limitation period from the date the negligence occurred. However, in a similar fashion to the last slide that I just discovered, if the negligence wasn't immediately apparent, claimants may have up to 3 years from the date of discovery, again, provided this doesn't exceed 15 years from when the negligence originally occurred. So a very similar rule on discovery. Well, what about personal injury claims? Well, for any personal injury claims arising from construction activities, the limitation period is 3 years from the date of injury, or if the injury isn't immediately apparent, 3 years from the date the injury was discovered. So again, it's that 3-year period discovery rule that applies. Well, since the Building Safety Act 2022 was introduced, it extended limitation periods specifically for claims related to defective premises. These changes reflect a heightened focus on building safety, particularly in the wake of issues around fire safety and structural integrity in high-rise residential buildings. So let's break down the key extensions that was introduced by way of the Building Safety Act. Well, first of all, there has been a retrospective extension for claims under the Defective Premises Act 1972. For existing buildings, the limitation period for claims under the Defective Premises Act has been extended to the significant period of time of 30 years retrospectively. What does it mean retrospectively? This means that claims can be brought up to 30 years after the building was completed, notwithstanding that the building was completed before the Building Safety Act came into effect. So notwithstanding the fact that the Building Safety Act only came out in 2022, buildings that were built before this, there is a retrospective 30 years limitation period. In terms of Defective Premises Act claims, this applies to claims where it's alleged that work on a dwelling was not done in a professional or workmanlike manner or did not make the building fit for habitation. There is also introduced by way of the Building Safety Act a prospective extension for new claims, and the limitation period here is 15 years. So for projects completed after, not before, this is for projects completed after the Building Safety Act 2022 came into force, the limitation period for claims under the Defective Premises Act is 15 years prospectively. So it's not 30 years, it's 15 years, and this applies to buildings that are built after the Building Safety Act comes into force. So again, it's a very significant limitation period, much longer than the 6 and 12 years we were discussing about. And this is because of the issues arising from Grenfell and the like. There's also one other thing that was introduced by the Building Safety Act, and that is the limitation period in respect of Section 38 of the Building Act 1984. The Building Safety Act activated Section 38, allowing claims for damages where breaches of building regulations result in physical damage. The limitation for these claims is also 15 years prospectively, meaning it is when any buildings that have been built after the relevant act, the Building Safety Act, has come into force. As you can see, with 30 years, 15 years, 15 years, these extended periods significantly increase the window for claims related to building safety. So it's essential for developers, contractors and consultants to be aware of the potential for claims extending decades beyond project completion, and therefore I cannot stress enough how important it is to retain records, and you will see that I have already uploaded a vlog on this, which if you're interested in, please go and check out. So, what is the importance then of contract review and documenting key dates? Well, this is very important. Knowing these time limits that I've just discussed is only part of the puzzle. There are a few things that you also need to do to try and stay on top of limitation periods. First of all, review your contract type. Check if your contract is a simple contract or as a deed, as this determines the relevant limitation period, 6 years or 12 years. If you want to consider additional protection, then you need to consider executing contracts as a deeds. we can provide advice to make sure that this is done properly. Secondly, and importantly again, is make sure you're setting reminders and tracking key dates. Set reminders for significant dates such as project completion, substantial completion, and any key events that could lead to a claim, because this helps track when the limitation period might begin and therefore when it will end and when you need to bring a claim in what period, as otherwise you will be time barred. When there's defects or other issues, make sure you're retaining documents that show when you discovered it. If you discover a defect after project completion, document when it was found and then consider seeking advice. This can be especially helpful if you may rely on the discovery rule to bring a claim that I mentioned earlier. Also, my advice is that you regularly review older projects. For contractors and project owners, it's helpful to periodically review older projects that might be approaching the end of their limitation periods to determine if there are any claims that may be made. You could therefore make protective proceedings and then seek to stay those while further information is obtained. But by initiating that claim, you have stopped any claim from being time barred because it stops the limitation period from going any further. So that's a summary of limitation periods in construction. Understanding these time limits and staying organized can help you manage risk and avoid unpleasant surprises. If you found this helpful, please like, subscribe, and leave any questions you may have in the comments. Also, I'd be happy to cover any topics that you may find of interest, so please leave it in the comments and then I can do the same. Thanks for watching and see you next time.